everyone again. Thank you so much for joining us. My name is Yusuf Raja. I will be moderating today's lecture. I am the founder and CEO of Ethiojobs. We have two distinguished speakers, Dr. Taxation. Dr. Taxation Lecho is an assistant professor of law at Addis Ababa University. And we also have Dr. Mahari Redai, who is an associate professor of law at Addis Ababa University. They will be addressing the law on tax and employment, especially the one that has been announced by the government. Each of them will address on their topic for giving about 10 minutes each. Then after that, we will open for a question and answer. Ethiojobs, many of you, as you know, is part of the company called InfoMind Solutions. And today's seminar is organized by InfoMind Solution. We do have a disclaimer I would like to read for everybody, and I would also repeat it in Amharic. InfoMind Solution PLC hosts this webinar which brings together participant and presenter to share information and ideas, all to benefit the webinar participant. This webinar are intended to be opportunities to exchange ideas for information purpose, and as such may include opinion, statement, materials, presentation, data, image, video, documentation, and other information collectively referred to as materials, expressed or otherwise shared by presenter or other participants. The materials are for general information purpose only and are not intended to be relied on by any person. I must always recommend that you obtain your own professional advice for your particular circumstances. Any statement, views, and opinion expressed on this presentation or in any material are those solely of the presenter or the participant, as the case may be, and not IMS. The materials and presentation at any webinar do not constitute advice, recommendation, or solicitation, and as such may not be relied on. IMS does not make any warranty, express or implied, and specifically disclaim any legal liability or responsibility for the occurrence, completeness, or usefulness of any of the presentation or materials. Basically, today's discussion is a matter of opinion, not necessarily as a legal advice. If you need a legal advice, we highly recommend you to speak to authority or to your lawyer. But just to make sure for the clarity, I will repeat the disclaimer in Amharic. Zila disclaimer የተጻፈው ለማስረዳት እንግዶቻችን የሚያቀርቡት ሀሳቦች በሙሉ እንደ ኦፒኒየን ወይንም የራሳቸውን አመለካከት አድርገን እንድንወስደው እንጂ እንደ ፍጻሜ ሆኖ ምክር አገልግሎት ተደርጎ እንዲወሰድ ስለማይፈለግ ነው። የምክር አገልግሎት የሚያስፈልጋቸው ከሆነ የኩባንያቸው አማካሪ፣ የህግ አማካሪ ወይም ደግሞ የመንግስት ባለስልጣንን ማነጋገር ይመረጣል ለማለት ያለው። Thank you very much. Okay. I would like now to introduce my first speaker. Dr. Taxation Lecho is an assistant professor of law at Addis Ababa University College of Law and Governance Studies School of Law. He teaches tax law and insolvency law at postgraduate and undergraduate program. Dr. Taxation is a nationally recognized expert on Ethiopian tax law and tax system. He has published a number of scholarly articles on tax and insolvency law in national and international law journal. He's a member of National Advisory Council, organized under the Federal Attorney General for Revision of Ethiopian Law, and has served as a member of subcommittee drafting a new insolvency law for Ethiopia, which has been submitted to the Council of Ministers for approval. So Dr. Taxation regularly contributes regularly to International Bureau of Fiscal Documentation, Amsterdam, IBFD, and the author of the Ethiopian chapter on corporate taxation, individual taxation, and business and investment. We also have another distinguished speaker, Dr. Mahari Radai. He is the Associate Professor of Law at Addis Ababa University School of Law. Mahari Radai, PhD, is an Associate Professor in Law at Addis Ababa University School of Law. He did his LLB degree, Bachelor of Law, at Addis Ababa University, and his LLM, Master of Degree, at the University of Michigan, USA, and PhD in Law at the University of Warwick, UK. He has taught and conducted extensive research, mainly on Ethiopian labor law since 1993. He has close working relations with the Ministry of Labor and Social Affairs, Confederation of Ethiopian Trade Union, and Ethiopian Employers Federation as well. Furthermore, he frequently consults some national and international business organizations operating in Ethiopia pertaining to their human resource management. As a practicing lawyer, he handled labor dispute and court of law in Ethiopia. I also have my colleague, Helena Negasa. She is the country manager of InfoMind Solution. She will be following up your question, and she will assist me in summarizing them and bring them to my attention. I now would like to call on Dr. Taxation to make his remarks.
Can you hear me? Okay,
yes,
thank you. Thank you, Ato Yusuf, for inviting me to this webinar. It's a great pleasure to participate in this kind of exercise. What I'm going to do is give you a very brief summary of the directive you mentioned at the beginning of this discussion, which is directive number 64/2012 or 64/2020. What it contains and the conditions under which the tax reliefs may be obtained. Now, the name of the directive is called Tax Date Remittance Directive 64/2012 or 2020 Gregorian calendar. But I am going to use tax waiver or tax date waiver, because remittance can be very confusing, particularly in the context of Ethiopia, because people are used to using the word remittance for the incoming flow of money from the diaspora. So I'm just going to use the word waiver or sometimes tax relief interchangeably. With that understanding, I just want to say that the tax directive, which was issued by the Minister of Finance about a week ago, does not cover all the tax reliefs which are being promised by the government. There are a number of tax reliefs, which are not really covered by the tax directives, but we are expecting that those other tax relief measures will be provided in a similar kind of directive. I think they are working on that just to make sure that the specifics and details and the conditions are worked out. For example, tax reliefs concerning rental income tax reduction or waiver have already been promised by the government, and I anticipate that these promises will be kept by the government. But as you probably know, Ethiopia is a federal country. Some of these tax reliefs must be provided by the regions. Payroll taxes, rental income taxes, some sort of property taxes, reliefs can only be provided by the regional government. But from the documents that I have read, which are circulating, there is a general understanding that these tax reliefs will be rolled out by the regional governments, and I've already heard, and there might be other regional governments which are doing this. I've already heard that the Amhara regional government has provided tax reliefs which are more or less similar to the federally promised tax reliefs that are provided. But they cannot be included in these tax directives because some of these taxes are regional tax jurisdictions. With that understanding, I'll just talk about some of the tax reliefs that are already provided for and the specific in the conditions in the directive. Now, the directive divides tax dates into two groups based mainly on the tax years for which those tax dates were owed or have been owed by the taxpayers. The first Class A or Type A tax dates are tax dates which were concerned with tax years prior to 2014 Gregorian calendar or 2007 Ethiopian fiscal year. So basically it divides taxpayers into two groups. There are taxpayers who follow Ethiopian fiscal year, which, as you may know, you all know, runs from Sane 1 to Hamle 1 to Sane 30, or the Gregorian calendar, which runs from January 1 to December 31st. So this Class A taxes or tax dates, with respect to these taxes, the directive states that these tax dates have been waived as a whole, which means the whole taxes, the basic tax, the interest and the penalties have been waived by the government. But they have been waived only as long as they still remain as tax debts. So if you have already paid, there is nobody is going to refund the money to you. You can only get a waiver of the tax debts. Now, the directive also talks about cases which are pending before the different tax dispute settlement bodies, the review committee, the tax appeal commission, or the courts. The directive says that these cases will be withdrawn by the tax authority, and the taxpayers will be notified of the waiver of all these tax dates based on the records that the tax authority has. Now, of course, the pending cases may be at a different stage of a dispute. There are when taxpayers may have won a case, let's say before the tax appeal commission, but let's say the tax authority has appealed to the court. In that case, if the taxpayer has won a case, which means the decision has been made in favor of the taxpayer will receive a refund of the money in accordance with the decisions of the tax appeal commission, and any deposit in the case of the tax appeal commission, the 50% deposit will be returned to the taxpayer. But any tax paid or deposit made in cases where no final decision has been made by the appellate bodies in tax dispute settlement, that will not be returned. So the government does not return any money which has been deposited. Even the amount of money which is deposited is much higher than the basic tax that is due. As you probably know, with respect to taxes which are owed and initiated before 2015, the requirement was to post a bond, a 50% bond, which is 50% of not only the tax, but also the interest and the penalties. So which means if you have paid, there is no refund given by the government. The other thing is that the directive says that the government will issue a tax certificate, basically acknowledging that all your tax dates have been waived, tax, interest, and penalties have been waived. So it's important to look out for that, just to avoid any kind of future dispute with respect to this Class A taxes. Now, of course, the directive reserves the right to the taxpayer to contest taxes. So if you still insist, in spite of all these tax waivers, if you still insist to contest the tax assessment, you can apply to the tax authority to receive a revised tax assessment notice without the interest and the penalty. So you can contest the tax, the basic tax, and then the waiver will remain. you know, the tax authority is saying there is no reason why taxpayers would like to contest this, because it goes against reasoning to contest a tax waiver which waives all of your taxes. But you can still contest the tax assessment against you. It also talks about installment payment agreements. There are taxpayers which were already in installment payment agreements. Again, if those taxpayers have paid the full taxes, there will be no refund. So the government is not going to pay anything to you. But if there is still an amount remaining, the interest and the penalties will be waived. Any amount of the basic tax, or the principal tax due, you can enter into a new installment agreement, and you can let me correct. Let me go back on this. If you are under installment agreement, and if you have any outstanding tax or interest or penalties, those are waived completely. So there is no need for you to apply if you have any taxes remaining under installment arrangements. But if you have any deposits, because you have appealed to the Tax Appeal Commission or courts, or if you have paid any advance taxes or excess tax, they will not be refunded, and nor will they be used to offset your taxes. I will talk about the property later on, and then let me just say something briefly about the Class B taxes. Now, the Class B taxes are the tax dates owed by taxpayers from 2015 to 2018, which means there are about 4 tax years that are covered in this. For those who are following the Gregorian calendar, for those who are following the Ethiopian fiscal year, this period covers the tax years from 2008 fiscal year to 2011 fiscal year. So the 2012 is still left out. With respect to these taxes, with respect to the previous Class A taxes, you don't have to apply. You get a tax certificate. It is a tax authority which will give it, so you don't have to go to the tax authority, whatever, but it's always good to go to the tax authority nonetheless, because if there is any dispute, you can resolve it there and then. Now, with respect to the Type B taxes, there are conditions attached to it. Number one, you have to apply to the tax authority for the waiver, and the waiver applies only with respect to interest and penalties, not to the basic tax. Upon application, you are required to enter into a new installment payment agreement with the tax authority, under which you agree to pay 25% of the basic tax due, whatever outstanding tax is due, within 30 days, and 75% the outstanding balance within 1 year. And there will be no interest and penalties applying on that basic tax due for that 1 year. Now, if you agree to pay the whole amount, if you have the money to pay it within 30 days, you will obtain a 10% tax reduction. So you will only be required to pay about 90% of the basic tax due if you agree to pay the whole amount within 30 days. Now, these are the conditions that you have to follow, which means that you have to apply to the tax authority that you want a tax relief under for those taxes, tax dates which are owed for 2014 to 2015, 2018, and you have to enter into an installment plan. Otherwise, you cannot take advantage of the tax relief that is available. Now, also the directive talks about the cases that are pending before the review committees, the Tax Appeal Commission of the courts, and the taxpayers. If they have cases pending before this, they have to withdraw their cases and bring the evidence of withdrawal of those cases to the tax authority. So one of the things that you really need to do after this directive is make sure that if you want to take advantage of the tax relief provided under the tax directive, the waiver of interest and penalties, you have to withdraw your cases before this dispute settlement bodies and bring that and enter into the agreement I was talking about earlier. Now, there are cases in which, let's say the Tax Appeal Commission has decided in your favor. and let's say the tax authority has appealed to the court. If the tax appeal commission has decided in your favor, this is good for you, which means that if, let's say, you have a complete reversal of the decision of a tax assessment, you owe the government nothing. Since you owe the government nothing, the bond that you have deposited will be returned to you. Or if the amount of tax assessed by the tax authority is reduced, the amount reduced, the difference between the amount deposited by you in order to appeal to the tax appeal commission and the amount reduced by the tax appeal commission will be returned to you. And it also talks about installment payment schemes, the taxpayers which are currently under installment payment schemes with respect to those Class B taxes. And if a payment was made under the installment agreement, excluded and exceeds the basic tax due, that means you are relieved. So if the amount that you have paid under the existing installment agreement exceeds the amount that is due, the basic tax due, then you have already settled your date, so you don't have to worry about it. But if there is a basic tax due still, the previous installment agreement will be cancelled and replaced by a new installment agreement, which gives you a new schedule of payments. And the taxpayer and the tax authority will enter into a new installment payment agreement in which the taxpayer agrees to pay 25% in advance and pays outstanding amount of 75% within 1 year. This also covers those taxpayers that have declared but not paid taxes. So there may be taxpayers who have declared their income, paid their taxes, they have declared their income and paid, but they have not received an audit with respect to these years. And the directive says if these taxpayers receive an audit, a new audit in the future, even after the issuance of this directive, these taxpayers have the right to apply under the new tax relief within 30 days of the notice to benefit from the tax relief. So basically, if you receive a tax audit, an additional tax assessment, even after the issuance of the directive, even though you have declared and paid your taxes, you can still apply for a relief of interest and penalties and agree to pay the basic tax, 25% upfront within 30 days and 75% later on. It also covers taxpayers who have declared but not paid taxes. So if you have declared taxes, declared your income, but for whatever reason you have not paid taxes, you can still apply, which means voluntarily apply to the tax authority within 30 days from the date of the directive, and interest and penalty waiver, and enter into an installment agreement to pay in accordance with the directive. Now, there is one consequential provision in the directive that all taxpayers need to take note of. With respect to Class B taxes, if the taxpayers have not applied for a relief, it is assumed that they do not want to benefit from the relief, and their cases will be treated in accordance with the regular tax administration laws. So it's very, very important that if you owe tax dates for this Class B taxes for 2015 to 2018, it's important to take action in order to benefit from them. Otherwise, the tax authority may assume that you do not want to benefit from that, and the regular rules will apply to you. And the other consequential matter is that once you enter into the installment payment agreement under the new tax relief law, the directive, if you fail to pay taxes in accordance with the installment agreement, the regular tax administration rules will apply. So you forfeit your right of waiver of interest and penalty because you have failed. So you have to be very, very compliant with a waiver of interest and penalties, and as well as the installment payment agreements. If you don't comply with it, then it is going to, the regular rules will apply to you. Now, I said earlier that the directive also talks about property seized by the tax authorities for the payment, as a security for payment of the tax dates. And with respect to the Class A taxes, you have to take action in order to take delivery of the property within a certain period of time. So you have to apply. And it is also stated very interestingly in the directive that you cannot take advantage of the release of the property from attachment, the repossession of your property from the tax authority. You cannot take advantage unless you are active in business, which is very, very interesting. The Minister of Revenue, I heard him say on TV that this tax relief applies only to taxpayers who are still active in business. So those taxpayers that have left Ethiopia without paying all these tax debts, their tax debts are there, at least they will not get their property back. But if you're still active in business and their your property has been held for the tax dates of Class A taxes, you can apply to the tax authority to repossess your property, and all kinds of attachments or injunctions that are issued on that property will be released unless there are other creditors on that property which have already obtained an injunction. With respect to Type B taxes, because there are still taxes that are owed, if you have already paid your taxes under the new scheme, because of your situation, the only thing remaining being interest and penalty, the tax authority will return the property to you. But if there is a tax, that basic tax that you own, you are entering into an installment agreement, there is an additional requirement that you have to fulfill. You can present a bank guarantee to the tax authority in order to obtain a release of the property which is seized for the payment of taxes. On the basis of that, the tax authority can allow you to use your property again. If you don't get that bank guarantee, by the way, the bank guarantee is interestingly for the not only for the amount of tax, but also for the interest and penalty, because there is an assumption that you might fail to pay even the basic tax under the installment payment. So that's basically my presentation of the directive. I just want to say a few things about the taxes which are not covered. There are many other taxes which are not covered, and we anticipate that this tax reliefs will be provided for in directives to be issued by regional governments, as is already done by Amhara region, and I'm sure there are other regions which I have not heard about. So these tax reliefs, the rental tax relief, which is a jurisdiction of the states, the payroll tax relief, the withholding tax that employers are required, and the VAT, the extension of the VAT payment collectibles until June. All of this, I think, will be provided for in future directives. Now, when I say directives, you have to understand that in Ethiopian tax administration, directives are not always issued in the format that we expect the directives to be issued. Sometimes a single letter is issued from the Ministry of Finance to the Ministry of Revenue. So some of these letters may already have been paid, but have already been issued and sent to the Ministry of Revenues, but we do not have access to these documents. Ato Yusuf, you were asking, how do we know whether these public documents are available? Issued in the form of directives, they are usually made available. I expect that both the Ministry of Finance and the Ministry of Revenues will make these directives or letters, memos or that sort of thing, sent to the tax authorities, make them available to the taxpayers so that taxpayers can take advantage of the tax reliefs that are provided. With respect to regions, you have to talk to the individual regions, whether it is Amhara or Tigray or Oromia, whatever, you have to talk to those regions. I am expecting that all of the regions will keep of giving at least the tax reliefs which are provided for by the federal government or anticipated by the federal government. With respect to Amhara, which is very interesting, they have provided similar kinds of tax reliefs, They have even gone further and said, if you pay your taxes for the Class B taxes at once, you will get a 15% tax reduction instead of a 10% reduction, which is under a federal tax directive that I was talking about. If,
Dr. Tadessa, can you hear me? Hello, Dr. Tadessa, can you hear me? I would appreciate if you could just wrap up, and maybe we could address the discussion during the Q&A.
Yes, of course. Yeah, I'm almost done. So that's
Thank you.
That's basically it. You know, there are a number of other reliefs which are related to taxes. As I said, principally the government has not promised to return taxes which are already paid. The government has only promised to waive taxes which are still debts. So if you have already paid taxes, the only relief that you can expect from the government is in the form of other kinds of financial assistance, like loans, you know, very low interest loans, as was, for example, promised by the National Bank of Ethiopia yesterday to the hotels, to the hospitality sector. I think they are rolling out a loan scheme of up to the tune of 2 billion Ethiopian birr for the hospitality sector. So those kinds of companies that have already paid taxes, they cannot expect to get any kind of refund of the taxes that they have already paid for, with respect to this tax years. Thank you very much.
Thank you, Dr. Tadessa. Very elaborate explanation. If you click at the Q&A on your computer, there are a lot of questions that are addressed to you. While Dr. Mahari speaks, you can start reading them. Those of you who have raised your hand to speak, please do send your questions on the Q&A, because we have quite a number of attendants, and it will be very, very hard to go through everybody and give a mic for everyone. I now invite Dr. Mahari Radai to address or to give his comments on this topic. Dr. Mahari, you must unmute your computer and you can start speaking. Here you go. Thank you.
Thank you, Ethiojobs, for creating an enabling environment to share our views on this issue. My area of presentation is related to employment relation. How does employment relationship need to be regulated in the era of coronavirus in Ethiopia? As you all may be aware that we have two regimes of law that regulate employment relationship. One is the civil service employment regime that regulates employment relationship of civil servants with the government. The other law that regulates employment relationship is the so-called labor law employment regime that regulates the private sector mainly, including the state-owned enterprises, employment relationships in state-owned enterprises, and also the NGOs. So now our concern will be, we are going to, for now, ignore the civil service employment relationship for now. It's not relevant for the present deliberation. So we are going to discuss the labor law employment regime. The labor law, that is 1156 2019, is a recent proclamation. Of course, it's an amendment from the previous one. It tries to regulate employment relationships, rights and obligations of employees, employers, and grounds of suspension, grounds of termination, employment injuries. A lot of things are included in that instrument. Now, with the current crisis of corona, some of the provisions of the labor proclamation seems to be impliedly repealed. Earlier, when a crisis of such magnitude occurs, there was a possibility for the employers to do two things: either to suspend employment relationship or to terminate employment relationship. By suspension, we mean until such time that the force majeure situation is avoided, the employer had the right to suspend a contract of employment. That is as good as leave without pay. This was indicated under Article 18, sub 5 of the Labor Proclamation, that says if an enterprise, because of force majeure, disrupts operation fully or partially, it had the right to suspend employment relationship. The only obligation expected of such enterprise was that it had to report this within 3 working days to the Ministry of Labor and Social Affairs, if it is a federal entity, or if it is operating in the regions, to report this situation to the regional labor offices. Once this report is given to these pertinent organs, the organ will see to it whether there is valid ground for suspension within 3 working days again. If the organ is convinced that indeed there is valid reason for suspension, there is a force majeure that disrupts operation, it will grant or it would affirm the measure of the enterprise, or even if it fails to give response within 3 days, it was considered as though it has already accepted the ground. The other possibility is the labor office may deny, saying that there is no justified ground for suspension. Then in that case, there was a possibility to go to appeal by the enterprise against the decision of the government authority. The maximum period for suspension was 3 months. If within the 3 months the force majeure situation is avoided, well and good, the employees will be reinstated to their previous position. But if unfortunately the force majeure is moving beyond the 3 months period, the contract of employment was to be terminated. The other possibility was termination. If because of a certain circumstance, there is a problem in production, marketing your products and services, there was a possibility to terminate a contract of employment of employees because of that circumstance. You may be required to reschedule or rearrange your working system. Some of your employees could be redundant. Some of your employees could be, if you are working in 3 shifts, you may decide to work in 2 shifts, etc. With this, there was a possibility to terminate a contract of employment by giving notice to the employees. But currently, with the coronavirus crisis, the regulation that was declared by the Council of Ministers states that there is no possibility of terminating a contract of employment without following the direction of the Ministry of Labor and Social Affairs. Fortunately enough, the Ministry of Labor and Social Affairs has earlier than the regulation, we had what we call a protocol that was issued by the Ministry of Labor and Social Affairs as to, in times of the corona crisis, how labor relation or industrial relation will be regulated. Legally and technically, actually, protocol is new to Ethiopian legal terminology. Under Ethiopian law, binding instruments that we had was proclamation, regulation, and directive. Proclamation is to be issued by the parliament, regulation is to be issued by the Council of Ministers, and the directive was to be issued by an individual ministry of an agency. But now this protocol, it appears that as though it was a tripartite document that involves the government, employer representatives, and labor representatives. That is what we call tripartite relationship. But when we try to closely view that document, it was single-handedly issued by the Ministry of Labor and Social Affairs. So it is difficult to say that it is a tripartite instrument. So prior to the regulation, the status of that protocol was very much controversial. Is it a recommendation? Is it a binding instrument? If it is a binding instrument, is it going to bind employers who are members of employers association, or does it cover to all employers even if they are outside of that membership? It was very much debatable. But now, with the coming of the regulation, the protocol gains legal validity because Article 318 of the regulation, the state of emergency regulation, as I indicated earlier to you, says that employers who are being regulated by proclamation number 1156 of 2019 cannot terminate a contract of employment without complying with the direction given by MOLSA. So that direction, the protocol is the direction. So there is a need to see what is the content in the protocol. The protocol tries to cover many things, beginning how to prevent the spread of coronavirus at workplaces. It tries to impose a sort of bilateral care, meaning care that needs to be taken by the employers on the one hand, and care that needs to be taken by the labor force on the other hand. So let's try to see what are the obligations or the requirements that are expected to be performed by the employers that are new to the current crisis. I mean, those additional obligations that were not stipulated under the labor proclamation that are added by the protocol. First of all, for those enterprises who made or who make transportation facility available to their employers to go to the working place and back home, they will be required to provide a transport service that will carry 50% capacity. So earlier, if they were providing 5 buses for their labor force with 50% capacity, they will be required to provide 10 rounds at least, either 10 buses or to make it 10 rounds. It is to ensure, I think, physical distancing while transporting employees with a view to avoid the spread of coronavirus. That transport facility need to be well ventilated, well sanitized. At the gate of the premises, employers are required to make available soap and water for hand washing or sanitizer, mask and gloves, and training employees how to make use of these masks and gloves, when to make use of them, how to make use of them, and where to use of them. Once the employees enter into the premises, enterprises are required to allocate individualized lockers to every employee in order to individually or privately put their working clothes and lock. So this locker needs to be neatly maintained. It also be privatized. Then at workplaces, especially for those who work, whose work production process requires a sort of close proximity of employees, that will not be allowed. They need to be sparsely positioned in order to distance them each other. So in an assembly type working system, physical distancing at workplaces need to be secured. So this again may displace some of their employees. The other thing, where enterprises make available of a meal service at working place within the premises, they will again be required to prolong the meal provision time so that employees will be entering in small numbers. Again, this is an aspect of physical distancing anyway. Then, if circumstance dictates to terminate a contract of employment, unlike the earlier times under the labor proclamation, the protocol requires employers to comply to the following things. Instead of directly terminating, they need, if there is an unutilized annual leave, employees need to be given annual leave. If employees have already consumed their annual leave, employers will be required to borrow an annual leave from the coming budget year to the extent of half it. Annual leave, as you all know, is leave with pay. So the employees will remain on their leaves with pay. Then other areas that are included in this protocol are, if they already exhausted their annual leave, and if the situation is not to be remedied as we see it now, then the protocol allows the employer to cut down allowances, transport allowance, housing allowance, whatever other allowances may be slashed, and the employee will be given only the wage aspect, the salary aspect. Then if there was a sort of bonus, a sort of product bonus or whatever, these benefits also can be also slashed out in order to ease the burden that may be imposed on the employer. I think that is the purpose. Then if there was under a collective agreement or whatever, a plan to have a salary increment, the salary increment also may not be applied if it is not already put in effect. If there was a collective agreement negotiation, collective bargaining, that may include salary increment and bonuses, they may be withheld to the coming 12 months. If with these all exercises, the situation cannot be remedied, then the protocol again gives the employer to provide loan to the employees, to give them assurance that they will be reinstated to their employer when circumstances permit, and send them out from employment. That is again one proposal that has been proposed by the protocol. So it depends sector by sector. There are many sectors that are directly and seriously affected. There may also be few sectors that may not be affected by this. So for those who are adversely affected by this problem, I think these are the things that has been spelled out by the protocol. In this connection, what does that mean? Is that termination of a contract of employment is prohibited outside of the direction that has been given by the Ministry of Labor and Social Affairs? Does it mean that if someone, an employee, commits serious disciplinary wrongdoing at workplace, does it mean that he will not be terminated? Does it mean that an individual who attains the age of retirement may not be terminated? We can think of a lot of things. Of course, the drafting of the protocol had problems, birth defect, so to say. But for me, it is not actually giving immunity to employees who are ill-disciplined. The purpose, I think, for me is to protect employees who are performing with strict work discipline at workplaces. Otherwise, if someone commits fraud at workplace, or if someone assaults a supervisor or a workmate at a workplace, is responsible for quarrel at workplace, I don't think the protocol protects these kinds of people. So on disciplinary grounds, there is a possibility of terminating. That is my view. It may be debated anyway, but the way I understand it, the spirit of the protocol is not to protect ill-disciplined people. It is rather to protect people who are ready to work, who are competent, who are disciplined to work, but because of the circumstance, they are at the verge of losing their jobs. This is how we need the spirit. Instead of the words of the protocol, we need to understand the spirit of that. If people attain today or next month their age of retirement, the age of 60, I think enterprises are at their right to terminate the contract of employment because of this issue. If employees are ready to resign by them on their free will, I think they are also entitled to leave their employment relationship. So this is the way I understand it. I will be addressing your concerns in question and answer times. Thank you.
Thank you so much, Dr. Mahari, for that elaborate explanation. Thank you, participant. Dr. Mahari, if you look at your computer, there is a section that says Q&A. You can open it up and start reading them so that you may address a question. I do want to give the mic quickly to Daniel. Daniel is also a tax expert. Maybe he can give a comment as well as address some of the questions that he raised that I thought was important. So let me, Daniel, can you hear me? If you can hear me, I would grant you a mic to speak.
Hello.
Okay,
Hello.
Daniel,
Can
go
you hear
ahead.
me?
Yes, we can
Okay.
hear you.
Okay. Actually, have some question for Dr. And I've put it in the question and answer section. Actually, my first question is regarding the tax relief or the tax waiver. So the tax waiver gave us the opportunity to waive all the tax errors. So my question is, with these tax errors, there are also allegations or some tax evasion questions. So my question is like now we have got the waiver of tax. What about this allegation? Now we are accepting the offer given by the government. So if we accept this offer, can they continue their allegation regarding this tax evasion, whatever allegation, maybe criminal liabilities? That is my first question. Hopefully you got it. And my second question is like now currently, practically, when taxpayers are going to Addis Ababa City Administration, they are being refused to be given this offer of directive number 64 2012. I thought that the directive number 64 2012 is for everyone, because it's not clearly stated that it is only applicable for the federal taxpayers. So my question is, even if you see it in the principle of equity or fairness, they giving this tax relief for federal taxpayers and refusing to give the same for those who are paying in Addis Ababa City Administration, it doesn't look fair. So that is just, I'm asking just for the opinion here. The other one is related to the tax relief. This tax relief is given for only those companies who have tax errors. What about those companies who are doing great, who are paying taxes on time, they are fully compliant, but I don't see any support given to them. So this is also an opinion. I'm just asking Dr. Tadesse. So, and the other one is regarding this, all this tax relief or tax waiver proposal was presented on the Council of Ministers on 90th meeting. Unfortunately, I read the proposal. Then I was expecting the overall decision to be issued on this 90th meeting of Council of Ministers. So I was checking the websites, asking for friends, but I couldn't get one. 18th Council of Ministers is issued, 20th is issued, but 90th is not issued. So why is what is the reason? That is the other question that I have. And the other one is regarding those, it's already addressed, but I still want to insist on it because I read the news that the VAT can be delayed for 1 month. So I advised to delay it for 1 month, but at the end of the day, the Ministry of Revenue it's not they were not communicated of this fact. It's already advertised in the news, and it's not communicated to the major the implementer. There should be some way, I think, some framework of communication, because Ministry of Finance approved this offer, and it's not communicated to the Ministry of Revenue. And I like my question here: is there any legal framework to communicate such directives, such the tax waiver relief? So this is overall my question. Thank you very much for giving me this opportunity.
Thank you, Daniel. We do have over 54 questions. I hope the presenters are reading them so they can summarize some of the questions. We will have response in writing, then we can email it to you. This is also being recorded. You can always come back and listen to the session again. Unfortunately, we will not be able to address all of the questions, but we will highlight some of the questions. But I do have Aster from Ilri. She has her hand raised for a long time. Let me give her a chance to speak. Then we'll take one more question. Then we'll go to presenters to address some of the questions that you have raised. Okay, and I do understand this webinar is supposed to end at 10:30 in about half an hour or maybe less, but we did extend it another half an hour if you would like to remain and listen to some of the questions. Okay, Aster, if you're still there, you may address the question now.
Good morning, everyone, and thank you very much for the nice presentation, Dr. Taddesa and Dr. Mahari. And thank you very much, Infomind, for organizing such a wonderful presentation, I must say. It's really timely. So my questions are like two. First, this question is actually for Dr. Mahari with regards to the labor law, the new proclamation, which was set by the Ministry of Labor and Social Affairs. So my question is with regards to terminating employees. For example, international organizations, whenever they recruit people, they don't normally just provide an indefinite term employment contract the way we have it with other organizations or undertakings in Ethiopia, because this organization normally operate with the fund that they get from different donors. So the two conditions that we normally put in the advert, for example, in our case, in International Livestock Research Institute, is first, we normally just say like the contract is for 3 years and renewal is just contingent upon the performance of the individual as well as availability of fund. So at the end of the 3 years, if the person, so for the employee actually to get renewal, further renewal, we need to have like the two conditions in place. First and foremost, they need to perform well as per the performance management system that we have. Second, we need to also secure funds. So if we have, like, for example, have a few cases where I was just advised to terminate the contract because there is no fund. So does that mean that we are not allowed to end the contract? Is it a must for us to renew the contract, taking into consideration the new proclamation? That's number one. And the other question maybe for Dr. Taddesa is, I know he just has touched upon those tax remittance or waivers with regards to organizations or businesses, but my question is with the employment tax. Rumors are just, just around in this town that there's a decision by the government to cut employment tax. In fact, even I was told even that was also on the reporter. Is it true, or if it's just that's correct information, maybe he can just, unpack that so that we can also advise our employees. Thank you so much.
Thank you so much, Aster. Thank you for asking question. I will take one more question, and then I will give the participant the chance to respond. I want to give now Nabat the mic. I did see Nabat raised her hand. If she's still there, I would. Okay. All right. So I don't see Nabat. All right. She must have been gone. Okay. Those of you just who came in late, I would like to remind you that we would extend this webinar for another half an hour, and it is also being taped and recorded, so you will be able to come back and listen to some of the questions. Okay. All right. Maybe now I will give Dr. Mahari the mic to respond to some of the question that has been raised, and also to the question that was written on Q&A. One important question I'd like to add to Dr. Mahari, he was asking if some of the NGO are already had terminated notice to their employee, due to end of project or fund being disconnected from the donor, can they still go ahead and terminate them? Can that be allowed to do? Because this was noticed, this notice was given before the state of emergency declaration. Okay, Dr. Mahare, and please unmute and maybe address some of the questions. Then we'll go after you. We'll go to Dr. Taddesa.
Thank you, Yusuf, and I would like to appreciate the concern of the participants. Two things. First of all, in my presentation, I stated that NGOs are being covered by the Labor Proclamation. Actually, that was not the intention of the legislator. The legislator had delegated to the Council of Ministers to come up with a law that regulates employment relationships in religious and non-governmental organizations. But until such time, the Council of Ministers come up with this type of regulation, they will remain as subject matters of this Labor Proclamation. So NGOs are under this Labor Proclamation as a default mode. So basically, this Labor Proclamation tries to see and regulate employment relationships in profit-making enterprises. And if you try to see the protocol, it was being crafted taking into account kind of working relationships. But since we don't have any option to regulate them, they will be subject matters of this. Of course, for those people in business, the government, by putting obligations on them, it tries to give, it is planning to give benefits, like what Dr. Taddesa was mentioning. There was a sort of tax relief. In some areas, there may be soft loan coming in. And they will be given some incentives in order to compensate the costs that they may incur by paying to non-working employees. But NGOs doesn't have that kind of opportunity. They cannot take
Dr. Mahari, it looks like your computer is froze. Okay, we will give him a chance when he comes back again. Meanwhile, I will ask Dr. Taddesa Lenjo. Dr. Mahari, are you back?
Sorry?
Okay, you were interrupted. Maybe come back and address our questions, please.
Yeah, so in this case, if it can be verified that the project has phased out, there is no money to pay, I think NGOs can do nothing. But in order to access action, they need to consult with the Ministry of Labor and Social Affairs, show them their account, their contractual agreement as to the phase out of the project. Actually, it's not the term that matters. If you say an employee was employed for 2 years or 3 years, it doesn't mean that you can terminate his employment at the expiry of 3 years. The labor law doesn't work that way. It is whether the job exists or not that matters. So the project has phased out. They can still get the instruction of the Ministry of Labor and Social Affairs as to how to go about it. Otherwise, they cannot pay from their own pocket. And this is a civil liability. So if they have nothing at their coffer, they can do nothing. The other thing is, how can business comply with rules? The cost is very much. the job is not there. So how are they going to manage the circumstance? As I indicated earlier, it's not only the obligation that has been stipulated. In another area, through the tax authorities and through the Ministry of Finance, the assumption is that there will be an incentive that will be given to those enterprises to make their life better. So it is with this understanding that these obligations have been imposed. Since the Ministry of Labor cannot give these benefits through its own channel, it cannot spell them out in the protocol. It is rather through the tax authority and the Ministry of Finance that these benefits could be obtained. Thank you very much.
Thank you so much, Dr. Mahari. Please go ahead, continue reading some of the Q&A and write a note. Maybe we'll come back again so that you can respond some of questions that are addressed to you. I would now like to give the mic to Dr. Taddessa Lejo to address some of the comments and questions raised by the participants. Dr. Taddessa, the mic is yours now. Dr. Taddessa, can you hear me? Dr. Taddessa? Okay. Meanwhile, I think while Dr. Taddessa is trying to figure it out his computer, I understand that Nebat is back. Maybe I can give her a mic until Dr. Taddessa comes back. Nebat, go ahead and address your question, please.
Thank you, Yusuf. My question was regarding the ability by organizations to maintain paying their employees while there is a significant disruption or complete shutdown of their businesses. So as we've heard, as stipulated by the state of emergency regulation, they cannot terminate their employment contracts. But after they have done everything in terms of removing allowances and freezing salary increases, if they're still not able to pay, then it will be very difficult to maintain a positive relationship with their employees. So I was wondering if there is any legal recourse that employers can take in this regard. Thank you.
Thank you so much, Nebat, for making it brief. Thank you. I think Dr. Taddessa is back. Dr. Taddessa, can you address some of the questions and comments raised by the attendees, please?
Thank you. If I forgot some of the questions, please remind me. So I'll address some of the questions which I was able to read from the Q&A, and also questions which are more or less repeated by Daniel. They are already provided for in the Q&A. The first question is, how about an exemption of employment income tax? Both the recommendations of the Ministry of Finance and the directives we have now do not have any exemption for employment income tax. The idea is to retain employees in order to incentivize employers to retain their employees. What the government did was to allow those employers which are still paying salaries to retain the employment withholding taxes for 4 months, which the government hopes will cover at least half of 2 months' salary. So it's a kind of cost-sharing scheme that the government has adopted. So the idea is not to exempt employees from income tax. The idea is to support employers to retain their employees during this COVID crisis. And that's what the government is doing. Now, a question that has been raised by a number of participants in this connection is that this is not provided for in the directive. The reason why it's not provided for in the directive is because employment income tax, which applies to employees of private companies and private NGOs, whatever, is not the jurisdiction of the federal government. So the Ministry of Finance does not have the power to force regions to keep the employment income tax. I am expecting that the regions will issue similar kinds of tax reliefs, which will allow their employers, the private employers in particular, to retain the employment income tax for 4 months. I'm fairly confident that this will be issued in the form of directives or some kind of letter by each of the regional states that are implicated in this. So that's a first question with respect to employment income tax. There is no exemption for employment income tax, only retention by the employers. The other question that was raised in the Q&A is, will companies who declared their taxes but did not pay, will they be audited? The companies that declared but did not pay may be audited with respect to Class B taxes, not to Class A taxes. For all purposes and intents, we can now assume that tax dates which are owed for tax years prior to 2015 are completely waived. So I don't think the tax authorities will audit. Even if they want to audit, as you know, there is a period of limitation that applies. Tax authorities cannot audit tax for tax years which are in excess of 5 years. So that's the basic rationale. So there will be no tax audit with respect to taxes which are owed prior to 2015, perhaps with the exception of tax evasion cases, in which case the tax authority has an unlimited power. So there is no fear of tax audit with respect to taxes which are owed prior to 2015, but for 2015 to 2018, it is already provided for in the directive that it is possible that the tax authority might still audit your company, might audit the taxpayer, and they might issue an additional tax. But the good news is that the only tax that will be imposed upon this taxpayer is a basic tax, which is subject to the installment payment scheme. So the interest and the penalty will remain waived. The other question is, somebody asked about how do we plan for these tax reliefs. As I said, if you owe tax dates which with respect to tax years prior to 2015, you don't really have to do much. You can just sit back comfortably and say, well, those taxes have been waived as long as you are active in business. And in fact, the tax directive imposes an obligation upon the tax authority to notify each taxpayer from their records of a certificate of tax relief, tax waiver. So you don't have to do much unless you have a property seized by the tax authority, in which case you have to take action. With respect to the Class B taxes, you have to take a number of actions within the time limits provided for in the directive. One, you have to go to the tax authority and agree to pay the basic tax, 25% of the basic tax and 75% of the outstanding tax within 1 year. In order to take advantage of the tax relief, you have to also withdraw cases which are pending if you have appealed by yourself. Withdraw cases. So there are a number of cases, actions that you have to take, and please read the directive very closely if the type of tax you owe is with respect to the tax years of 2015 to 2018. Are there any, somebody asked, are there any additional tax incentives that are being considered? I think we are still, this is still a developing story, in the sense that the government might still provide additional tax incentives other than just mere tax waivers. What are they going to be? Unfortunately, I'm not within the government to know what is developing. But I expect that if things get very harsh for some of the businesses, they may give additional tax reliefs for future tax years. Right now, the focus of the government is to make affordable loans available for small and medium enterprises, for the hospitality sector, and et cetera, et cetera. So the National Bank has already taken actions with respect to that, with respect to financial assistance. But there might be tax incentives. Now, also remember what is not included in the tax directive, but will be included in future tax directive, I hope, is that there is a provision about losses which are incurred this year will be carried forward to be deducted from future tax years, even if the company concerned has exhausted its right of loss carry forward. Under Ethiopian income tax law, any company cannot carry forward a loss for more than 2 tax years. So even if a company has used loss carry forward rights for 2 tax years, it still can use a loss carry forward for this COVID year, I should say, in the future. So that is a sort of incentive that is also provided. Another person asked, what is the benchmark for these 2 tax classes of taxes? I don't know, but part of the reason why they have divided these 2 different tax periods is because the period from 2014 and prior is already closed off for tax audits. So because of the 5-year period of limitation. So the tax authority is basically saying, we're not going to audit this because of the legal barriers. So we are going to waive it as well. They are also saying, okay, we have to provide some kind of tax relief for taxpayers which are really hard hit by the closures of the COVID. But the main reason why these tax reliefs are provided, as stated in the directive and the other background documents, is for retention of employees and for keeping businesses afloat to the extent possible. So the government is trying to share the costs of businesses. It is also trying to incentivize businesses to retain their employees for this period. That's why I still insist that businesses which are not active in actively doing business right now may not be able to take advantage of the tax reliefs that are provided. Somebody asked a very provocative question about, are millionaires or billionaires behind this? I have no idea. They obviously they stand to benefit from this tax relief, but I don't know who is behind this. My belief is that the government is very sincere in its decision to provide some kind of tax waiver for a variety of taxpayers. If billionaires, they exist and millionaires stand to benefit from this, well, that's the way it is. This is the nature of a general law. The other, I think Daniel raised this, is I think some people have gone to the city the Addis Ababa city administration, and they have not received the tax reliefs. I think my guess is the city administration has not acted in accordance with the federal recommendations of tax reliefs. As you can see from the background documents, the recommendations is that all regional governments will take similar actions to provide similar reliefs for taxpayers which are subject to regional tax bumps. Now, Addis Ababa is constitutionally is not a region. It is technically under the federal administration, although it has its own autonomy under the constitution. I think I am almost 99% certain that Addis Ababa will provide the same kind of relief, if not more. One, because the recommendation is for all regions. So I would be very, very surprised if Addis Ababa city administration has decided to go against the federal recommendations. Secondly, the federal government can technically force Addis Ababa to provide the same kind of relief, because Addis Ababa is not like Oromia or Tigray or Amhara, which are regional states with their own autonomy under the constitution. So I think this relief will be provided. It's a very common experience in Ethiopia that when certain new laws are issued, the implementing agencies may not get the information on time in order to implement them. So there is a lack of communication in this regard, but I think this lack of communication or coordination will be resolved very, very soon. That's my guess, and I hope Addis Ababa is not going to go against a federal recommendation. We have already seen the Amhara region providing the same kind of recommendation. It's going to be a very common kind of tax relief provided throughout the country. Some regions might even go further than the federal government recommendations in this respect. There is another question raised in the Q&A. What about companies that do not have any tax dates? They don't have a tax arrears because they have fully paid their taxes. Unfortunately, there is no tax relief for those companies which have already paid their taxes. That is a price of compliance sometimes, unfortunately. That's the way it is. For these companies, the government is providing affordable loans or other kinds of financial assistance, not refund of any kind of tax. But the government might decide to return in the future, I don't know. But in the tax recommendations and the directives, there is no mention of returning or refunding money to the companies which have fully paid their taxes. What happens to those companies which did not declare their income and pay the tax? It's not very clear. It does not appear that the directive covers those companies which have not declared nor paid their taxes for the tax years concerned. So it's quite possible that these companies are not covered. My suggestion is please talk to the Ministry of Finance and ask them if the tax companies which have not declared and paid their taxes can take advantage of the tax relief. Because under the directive, the Ministry of Finance has broad powers of even giving waivers which are not necessarily indicated in the directive. The other question which Daniel raised is criminal liability, particularly issues of tax evasion. There is no mention about waiver of criminal liabilities in the directive. My suggestion is that if there are pending criminal cases against your company with respect to tax evasion, for example, you have to, when you sign the installment payment agreement to pay under the new schemes, please make sure that to insert a provision that says this is not an admission of a criminal liability. My guess is with respect to the Class A tax dates which are owed for the years prior to 2015, the government has already decided to discontinue any criminal cases with respect to that. But this is something that you have to verify. Don't rely upon my words. Now, Daniel asked the question about the Council of Ministers 19 meeting. Those are issued in the form of letters. Some of them are not publicly available. I guess that question should be addressed to the Council of Ministers. Can you hear me?
Yes, Dr. Tatsan, we can hear you.
Okay, very good. I think that question that Daniel raised, that is a question for me as well. There is a lack of publicity and transparency with respect to these decisions, because sometimes you have to wonder whether you have to rely upon some of these press statements. My suggestion is that do not rely upon press statements, because there are lots of distortions in the newspapers and that sort of thing. Sometimes you may not get the right kind of information. Don't rely upon information that is available in the newspapers or over the radio or the TV unless it is backed up by something else, which is a real document like a directive or a letter issued by the Ministry of Finance. But I'm also concerned that some of these decisions are not properly communicated by the Council of Ministers. My guess is that they are under a huge time pressure. They are not being as efficient as they should be in this time of crisis. a related question is about the VAT. Now, with respect to VAT, there are two issues here. As you know, the VAT consists of the output VAT, the collectible, which you have to report to the tax authority, and then you need to get a credit for the input VAT. So sometimes what happens is that you have an input VAT, which you need a refund because you don't really have much of an output VAT in this time of crisis because the businesses are down, whatever. In that case, there is already a decision by the Ministry of Revenues to expedite a VAT refund procedure. There are still bureaucratic problems, but I have heard from people who have gone there that they are more responsive now when it comes to VAT refund procedure. So that's one thing. The other is the collectibles. It is already mentioned in the document that I was able to access, and I think you already have access to this, is that you can, the VAT collectibles can be retained for 1 month, and it can be extended, I don't know. But that's not communicated in the form of a directive. Now, these kinds of things are not normally issued in the form of a directive. They are issued in the form of letters or memos. So I think watch out for those letters which are issued by the Ministry of Finance to the Ministry of Revenues, which communicates these letters down to its departmental levels, as well as should make it transparent, I mean, public to the taxpayers. So I think that's what we have to expect, and we have to watch out for them. And unfortunately, I don't have access to those letters right now. But I'm expecting that whatever the document says should be done will be done in the form of letters or memos or some kind of communication between the Ministry of Finance and the Ministry of Revenues. Somebody asked a question about customs. Again, the directive does not talk about customs. I've spoken to a few people within the Customs Commission. They are writing a directive with respect to customs. There is one thing that I did not mention at the beginning of my presentation on this matter, which is that the directive applies only on taxes other than customs, because customs under Ethiopian tax administration law are treated separately from mainly the domestic type taxes like VAT, turnover tax, corporate income tax, withholding tax, and that sort of thing. So expect to get some kind of directive from customs with respect to the customs tax waivers. In the document, I have read that with respect to customs duties, the tax date that is covered is with respect to a specific type of customs tax date, customs duties date, in relation to abuse of transfer of duty-free imported goods. But I expect that that sort of directive or later will be communicated later. So I think some of those issues which are not covered in the directive, expect them to be issued in the form of either letters or memos or in the form of directives by the respective agencies. Rental income tax, employment income tax, these are regional tax powers, and it's each region which decides how much these tax reliefs, which are recommended by the federal government, by the Ministry of Finance, will be implemented by the regions. But I expect the regions to follow through these tax reliefs in their respective tax directives or whatever documents that they issue in order to provide these tax directives. If I have forgotten any question, feel free to remind me. That's all I have right now.
Thank you very much, Dr. Tadessa. Yarit Kabada has asked if this presentation video will be available. Yes, it will be available. We'll keep it online. You can come back using your access to watch the recorded video. I would give a mic now. I think Tigist has already left. Tigist has left. So, okay, Tigist is back. So let me give Tigist and Mulina a mic, Mulina Bible. Then, in addition to Nebat's question, I would give an opportunity to Dr. Mahari to speak. keep in mind, we will be done in 20 minutes. Please make it brief and also let us know whom you're asking the question to. Biggest, Bakala, you can go ahead and.
Thank you for the organizers. Informind and the guest speakers for providing this kind of. Hello.
Okay, because I think your connection is not good. If you don't mind, ask your question on Q&A, and we will try to address them. Sorry about that, Biggest. Okay, I will go to Mulana Bible. Let's try Mulana Bible. Mulana, if you can hear us, can you ask your question? Mulana?
Hello, can you hear me?
Yes. Can you speak up a little bit?
Okay, thank you very much. My questions will be to Dr. Tadessa. Dr. Tadessa was talking about the price of compliance and distinction between the tax compliant companies and others. But my question will be how the government will treat the tax principles in these companies. For instance, the tax neutrality and the non-discrimination principles in this COVID situation. The second question will go to the Dr. Mahari, and the first question will be how the state of emergency regulation will address the entitlements such as bonus payments that has been accrued for years but not paid to the employees. Are these entitlements will be cancelled due to this the Ministry of Labor and Social Affairs protocols or otherwise? The second will be how the summary dismissal cases will be treated if the causes of this summary dismissal cases are reasons due to the government actions. For example, how the employee will be late or will be late in work due to the measures that have been regularly taken by the government. For example, the transportation case. Thank you very much for taking my questions.
Right. Thank you so much, Mulana. Please address your question on the Q&A because giving a mic to everybody is going to be very tough. And but we will try as much as possible to address them. Dr. Mahari, questions that have been raised on a Q&A session and some of the questions that I was already asked using a mic. Please go ahead and address those questions. And we have 50 minutes left, and I will come back to ask you to give us a closing remark after Dr. Tadessa. But for now, Dr. Mahari, please go ahead and address some questions. You will need to unmute yourself. Okay, very good.
Thank you. I would like to reflect on two issues. One is the issue raised by Nabat. How can employers comply with this if the issue of coronavirus is to be prolonged? I think that is a valid concern in the sense that under Ethiopian law, even a single employer that employs a single worker is considered as an employer and as an employer, and thereby being regulated under this protocol. The protocol expects a lot of cost that cannot be incurred by, especially the huge ones may carry it for some time, but the small and medium enterprises will not, I am afraid that they have already exhausted their economic power at this level. So my understanding is that this protocol is a short-term measure that needs to be revised from time to time as actual circumstances come into existence. My understanding is the protocol was prepared on the assumption that the coronavirus issue would be done away with within short time. That is the reason why they said give them their annual leave. If they have already consumed their annual leave, give them from next year's annual leave at least half of it. So what then? Once that route has been exhausted, what will be the remedy is something that has not been addressed by the protocol. If you closely watch the protocol, it says this is a first level response to withstand the impact of coronavirus at workplaces. So the first level response is this. We are expecting a second level response to come up. Otherwise, not many companies would comply this for a very for a longer period than what we have already. So one, it is up to MOLSA to come and back sit to revise it. Two, it will be up to the employers through their association or individually to consult MOLSA as to how to go about it. The second question is, what about entitlements of bonus that has been long overdue? Does it mean that they will be also ignored, or would there be a possibility to obtain those things? I don't know how bonuses would move that long. I mean, even in law, if you have a benefit expected of from your employer, unless you collect them or you claim to collect them before a court of law within 6 months, they will be barred by limitation. So if there are bonuses that are long overdue for years, I am afraid that they will be barred by period of limitation, not by this regulation. I didn't get the point that was raised by the speaker as to the second question. Would you please tell me that? Thank you.
It will be okay. Let's. We only have about 10 minutes left, and I would like to ask Dr. Taddesa to respond, and I will come back to you, to Dr. Mahari, to wrap up your comments. Dr. Taddesa, can I give you a mic to speak now?
Yes, thank you. I think there are two questions that, as far as I know, that I really need to answer. One person asked, what does a 50% tax waiver mean? I think this refers to the rental income tax. It's not included in the directive, but the suggestion is that for those companies or individuals that obtain income from rental of buildings, which is payable under Schedule B of the income tax laws of Ethiopia, for this year, they are going to get a 50% tax waiver. Whether that is going to be made or not is another question altogether. There is another promise which the regions will have to confirm, which is if a landlord or a lessor agrees to waive the rental payments of its tenants for 2 months, it will get a rental income tax exemption for the whole tax year of the COVID period. Which tax year it is going to be, it's always confusing because sometimes the tax relief can fall on 2 tax years, but that is something that will have to be carefully crafted in the directives that need to be issued. But the second one is based on condition. The condition is that the landlord or the owner of a building must present an evidence showing the waiver of rental payments for 2 months at least in order to obtain 1 year tax relief. There is also a provision which is a sort of vague with respect to landlords or owners of buildings which are rented for small and medium enterprises and educational facilities. There is a condition that says that the educational facilities must waive payments for their students, tuition payments, that sort of thing. I don't know how these conditions are going to add up in the future, but we're looking for detail. But there are 2 things here. For all rental income taxpayers, there is a 50% tax reduction for the whole year. And for others, it can even be the whole tax reduction for the whole year if the landlords are able to present evidence showing that they have waived the rental payments of 2 months at least. Another question raised by Mr. Muluna Biabo is, those companies which have fully complied, they're not getting any kind of tax relief because they have already paid. Well, remember, this tax directive is a waiver of taxes owed. It's not a return of taxes paid. It would be very, very complicated, and obviously the government will not have the capacity. If you think about it, if you take, for example, taxes which are paid for the years prior to 2015, it would mean that the Ethiopian government will agree to return all the taxes that were paid for that period for all the companies. I think that's an impossibility, and we should not expect, not only Ethiopian government, even modern, highly developed, financially highly resourced countries cannot do that. So what the government is doing is waive the taxes owed, not return the taxes paid. Is this equitable? It depends on how you view equity. I believe that it's not up to the government to return all the taxes paid for the years from 2015 or whatever, or even to return the interest and penalties paid, because remember, the government is under heavy financial burden by itself because of the COVID. Its financial capacities are being considerably reduced because of the COVID phenomenon, which means that you cannot expect the government to go that far. What the government is doing in order to support these companies, which are not able to take advantage of the tax waiver scheme, is to provide them with affordable, cheap loans from the national banks, from the government bank, the Development Bank of Ethiopia. That is the kind of financial assistance that the government is talking about. And I think more or less, this is fair considering all the circumstances of the situation that we're facing. I don't think the government is expected to return the taxes that were already paid by the taxpayers. That would destroy the government, because the government will simply not have the capacity to return these amounts to the taxpayers concerned. I think that those are the only questions I have, but if there are additional questions, I'll be very happy to respond to them after looking at the board of the Q&A.
Thank you very much, Dr. Tadessa. I think we only have 4 minutes left, so I would give both of you a closing remark. But I do have Rahel Shoaye, who's been raising her hand for a long time. Rahel, if you can make your question very brief, I'll give you 1 minute to speak.
Okay.
Rahel, go ahead.
Okay, thank you everyone for the brief presentation. Are you hearing me? Hello?
Yeah, we can hear you. Go ahead, speak up.
Okay, thank you. So my question is, like the reason for this protocol is, I think, to reinforce organizations to stretch out as far as they can and to maintain a job security for their current employees, even by freezing planned salary increments or by paying different allowances that they are granting for their employees. So my question is, having this in mind, is this protocol totally enforcing organizations to automatically freeze planned salary increments which are already on process and to pay the different allowances that are granted to employees, or is there a room for organizations to assess their own capacity and to discuss with their employees and to make any salary increments or to continue granting any allowances or benefits to their employees? So my question is here: is this protocol totally enforcing organization to automatically freeze their to automatically freeze any planned salary increments, or they can do they have a room to assess their own capacity and to make their decisions regarding this?
Okay. Thank you very much, Rahel.
I think this is for Dr. Mahari. I didn't mention. Sorry.
Okay, thank you. It's clear. It's clear. Thank you.
Okay.
All right, Dr. Mahari, maybe if you can respond to Rahel's question, as well as if you have received additional questions on the Q&A, then also give us your closing remarks. Then we will go to Dr. Tadessa for closing remarks, and we should be done in 2 minutes, I believe. Thank you. Go ahead.
Thank you, Yusuf. I don't see any question under the Q&A, but I will simply reflect on what Rahel says. I think the level of adverse effect is not flat rate. There are many companies that have been seriously affected by this coronavirus issue. There may be few companies that may even better perform under this circumstance. So it depends on the level of the companies who have been adversely affected. If for a company that has not been, if it can be shown that a company has not been adversely affected, and if it tries to withhold allowances, obviously that would not be acceptable. The understanding and the way the protocol is drafted is that it is going to be seen case by case. The economic strengths, the levels of adverse effects sustained by this problem need to be considered. So in a situation where there is no adverse effect to the operation of a certain company, a company cannot does not have the right to automatically withhold benefits and other things. For those companies that are adversely affected, I am not sure to what extent that would be feasible. It even recommends that they can negotiate with their employers to revise the existing salary. To make a sort of salary reduction. But I don't know. It is left to the agreement of the parties. This has a conflict of interest issue. To what extent? For strategically looking employees, I understand that for the benefit of sustainability of their company, they may agree to that proposal. But for others, it may not be an acceptable action, but the protocol tends to propose to that extent, not only to deduct allowances, but also to deduct the existing salary to an acceptable level by both parties. So it is going to be taken case by case. It is going to be taken sector by sector, because every sector is not equally affected by this problem. This is one thing. Generally, I mean, the protocol is trying to manage crisis at workplace. It is expecting a lot from employers. Of course, for those employers who are in a strong economic position, they may struggle to comply with the requirements of the protocol for some time. But as I indicated earlier, since this protocol tries to govern including small enterprises, it will be difficult, even impossible, to small business enterprises to comply with the requirements of the protocol strictly. Therefore, there is a need to revise the protocol from time to time by looking at the reality on the ground, the length to how long we are going to remain in lockdown need to be considered, and it needs to be a living document that should take into account the reality on the ground. Thank you.
Thank you so much, Dr. Mahari. And I will provide the email for Dr. Mahari and Dr. Tadessa for those of you who would like to have a direct contact and maybe engage them in some of the law advice. Dr. Tadessa, if there are any final questions that you need to address, and as well as your closing remarks, please.
Thank you to Yusuf. I don't think there is any other question that I need to address. If I have missed, please feel free to contact me on my email, which will be supplied to you by Mr. Yusuf. I just want to say thank you very much, first of all, for affording me this opportunity to speak on this COVID-related tax measures that have been taken by the government. I just want to say that this is just a developing story. We already have one directive. Expect to have a number of other specific tax directives or letters or memos to be issued by the relevant bodies. For example, we expect the Customs Commission, for example, to come up with its own letters or memos, or even a directive on customs that issues that are addressed in the law. We expect regional governments to have their own relevant directives on these tax reliefs, and we expect them to be consistent with the federal recommendations. We expect issues like VAT and TOT retention and loss carry forward issues to be addressed in the coming weeks, because I think the government is developing that. So watch out for all these developments from the government, and make sure that you are effective in taking advantage of these tax reliefs, which are, even though in some cases the directive might say you don't have to do anything, my suggestion is that you have to go to the tax administration and ask for the specifics of your rights. Don't lie down and expect that you are going to take advantage of it, because you may be missing on a very, very important opportunity. So if you have rights under directive, take advantage of those. Make sure that you have taken all the actions that are necessary under the directive in order to take advantage of those. Watch out for the timelines, the deadlines. It says within 30 days of the directive, whatever. If there are no extension, you may be losing your rights if those timelines expire without you doing something about it. So if you are a taxpayer having the opportunity to take advantage of these tax reliefs, make sure that you take those rights very seriously, and make sure that you meet those conditions very, very seriously in order to take advantage of them. The other missing link here is there are going to be disputes. There are going to be disputes on in relation to this tax reliefs, on the extent of this tax reliefs. Unfortunately, the directive we have now does not have any specific tax dispute settlement expedited tax dispute settlement schemes for these kinds of tax disputes. And it will be very difficult for taxpayers to address issues, concerns they have with the extent of their rights under the tax relief law when you don't have a separate tax dispute scheme. I hope that the tax authorities will take account of this and will make some political decision to provide for a tax dispute scheme which will effectively address these issues outside the regular tax dispute settlement scheme. Otherwise, in some cases, when there are disputes, taxpayers will be forced to go back to the review committee, the tax appeal commission, which is again going to force taxpayers to go through the regular tax dispute scheme. And I hope this will be resolved in the future. Once again, thank you for affording me this opportunity.
Thank you so much, Dr. Taddasa Lenjo, and thank you so much, Dr. Mahari Radey, and I also want to thank all the participants. I really appreciate your time, and I will put the email one more time, but you can always reach out to our office, Helena Lagasa or myself. Most of you have my email already because you have registered, and we will put you in touch if you need to further information or further assistance with either Dr. Taddasa or Dr. Mahari. I want to thank everybody, and thank you so much. Please stay safe, and I wish you everybody a success in your business. Thank you and have a nice day.